chapter heading section 36, sorry, chapter 36 is limitation for taking cognizance of the offenses. Now, cognizance is a judicial duty, right? That the court has to apply its mind. Now, the question is, what happens when the complaint is lodged within the time? Investigation is also done within the time, but the court has not taken cognizance for some reason, or where the complaint is within the time, investigation has not happened, and therefore charge sheet could not be filed, due to which cognizance could not be taken within the time. Is it the purpose of section 468 to penalize all those complainants whose case could not be investigated on time, and therefore my voice is still not clear to anyone?
It's clear, ma'am.
It's clear. Anusha just said the voice is not clear. All right. So the question was, is the purpose of 468 to penalize even these complainants who have taken the action on time, but because of some other fault, either because of the investigating agency or because of the court, the cognizance could not have taken on time? Now, this is one question which had always riddled the courts, and there were divergent opinions. One of the landmark cases here is that of Japani Sahoo. The facts of this case are like this, that there is this man who has a lot of shops in Chandrasekharpur area, and he gets a handsome rent from those. The police people here, they know that this is a wealthy man who is earning handsome salary from the rental income. They charge hafta, protection money. Illegally, they do that. Now, this man has been paying somewhere around 5,000 per week as the hafta money. And now he is disturbed by, continuous harassment by the police officials. So one fine day, when the police official, they come to take this hafta money, he refuses to pay. And next day, he's summoned to the police station that, big sahab have called you to the police station. There also, he refuses to pay the hafta money, due to which there is a scuffle between him and the inspector of the police station. And he gets bruises and everything. They beat him up. Now, this man wants to file a case against the police officials. So he consults his lawyer. Let's say that this incident, hypothetically, I don't know the date exactly, let's say hypothetically that this incident took place on 1st July 1999. He consults his lawyer on the very day. His lawyer advises, see that if you report the matter to the police, they will obviously not file a case against themselves. They will never investigate. In fact, they would rope you in some false case. So it is better not to file an FIR against them. Instead, go for a complaint case. So as advised by his lawyer, after 2 days, that is on 4th July 1999, this man files a complaint case before the magistrate's court. So the magistrate, what he does, he examines the accused, he examines the complainant, he examines the witnesses of the complainant, and then he issues show cause notice to the accused. Summons are issued to the accused. However, the accused, who is the police personnel in this case, he is not coming before the court. वो summons answer नहीं करता, he is avoiding summons. And it is only after 1 year that when non-bailable warrants are issued against this police personnel that he appears before the court. And thereafter, court takes cognizance after the 1 year has elapsed. Court takes cognizance, let's say, on 20th August 2000. That is after a year the incident has happened. Now this police personnel, he has challenged the cognizance taken by magistrate after 1 year before the High Court. And High Court is impressed by the contentions advanced by the police personnel. that cognizance could not have been taken after 1 year as per 468 of the CRPC, and High Court quashes the criminal proceedings against him. Therefore, aggrieved by this order of the High Court, the complainant has come in appeal before Supreme Court. Supreme Court here did not agree with the reasoning of the High Court and said this man was diligent enough. He filed the case within 2 days of the incident. You cannot now penalize him for inactivity by the court or because of the accused itself. And accused cannot take the benefit of his own wrong. He avoided delay for, avoided arrest for 1 year. He avoided summons for 1 year. And now he cannot take the benefit of his not coming and saying cognizance cannot be taken after 1 year. Court in this case also applied the legal maxim that the act of court shall do no wrong, and therefore it said that the time for taking cognizance, which is prescribed under 468, is actually the time for filing of the complaint. Though they have used the word cognizance here, but it is not in strict sense that we are interpreting it. What the legislators meant here was that it is the time for the action to be taken by the complainant, either in filing the complaint or launching the prosecution. That is what is prescribed by 468. So in this case, because the complaint was filed within 2 days, which is very much less than 1 year, therefore they say that the complaint was properly filed and it cannot have been dismissed. It could not have been quashed by the High Court. So they applied purposive interpretation, then the literal interpretation of the court, and said under 468, the time which is prescribed is not the time for taking of cognizance by the magistrate, but it is the time for the taking of action. However, this judgment of the Supreme Court said that, we are overruling. It also said that we are overruling all the other judgments which have given a contrary decision. Now, this judgment was by a DB, two judges of the Supreme Court. Now, two judges of the Supreme Court cannot overrule another two judges' decision. It needs to be overruled by a higher bench. And therefore, in Sarah Mathew, the conflict was brought to the notice of the Supreme Court, and a constitution bench was therefore constituted. In that case, Sarah Mathew versus Institute of Cardiovascular Diseases, Supreme Court agreed with Japani Sahoo. 5 judges now agreed with two judges of two bench judgment of Japani Sahoo and said that the time which is prescribed under 468 is actually not the time for taking cognizance, but it is the time for filing of the complaint or launching of the prosecution. They upheld the principle of purposive interpretation. Otherwise, they said this chapter, if we strictly interpret it, would be liable to be challenged on Article 14 of the Indian Constitution, and therefore would be struck down as unconstitutional. And we cannot interpret in a way that renders it liable for being declared unconstitutional. So therefore, we are again, they upheld the purposive interpretation, then the literal interpretation. Now, the rule as it stands is that 468 is providing the time within which the complainant has to take the action, not within which the court has to take cognizance. So it is only complaint. Investigation के लिए जो time लगता है वो लगेगा. It is not the time for the investigation to be completed and then, charge sheet to be filed and magistrate to take action. No, it is not that fast. Cognizance actually is a step-by-step process. So first, initiation of criminal machinery, then investigation, then application of judicial mind. We only have to see step 1. Step 2 or step 3 ka jo delay hai, that will not affect the limitation of the case. And now, this judgment holds good. It has not been overruled. It's a 5-bench judgment, and all the other cases, which gave a contrary opinion have been